Hearing the appeal, Croydon London Borough Council against Kalonga.
Yes, that's right.
May it please the Court, I appear with Ricardo Calzavara for Croydon, and Justin Bates and Nellie Robbins represent the respondent. My Lord, this case concerns the ability of a landlord to apply for a possession order on statutory grounds under the Housing Act 1985 against a fixed-term secure tenant before the natural expiry date of the contractual term. It arises in the context of a flexible tenancy, a species of secure tenancy introduced by Part 7, Chapter 2 of the Localism Act 2011. But the parties agree that the principles arising on this appeal apply to any fixed-term secure tenancy granted by a local authority or other public sector landlord. My Lord, specifically, this case concerns the correct interpretation of Section 82 of the 1985 Act.
Right, the screen hasn't been set up properly. Please continue.
Specifically, this case concerns the correct interpretation of Section 82 of the 1985 Act, a key provision in Part 4 of that Act where the main body of rules concerning secure tenancies is to be found. So can I begin, therefore, by inviting the Court to turn to Section 82, which is at tab 7, page 336. My Lord, this is the current and for present purposes applicable version of the section. In due course, I shall be inviting the Court to look at earlier versions as well as a prospective amendment. As it currently stands, Section 82 reads as follows: security of tenure. 1. A secure tenancy which is either A, a weekly or other periodic tenancy, or B, a tenancy for a term certain, but subject to termination by the landlord, cannot be brought to an end by the landlord, except as mentioned in subsection 1, capital A. Section 1, capital A, the tenancy may be brought to an end by the landlord, A, 1, obtaining 1, an order of the court for the possession of the dwelling house, and 2, the execution of the order, B, obtaining an order under subsection 3, or C, obtaining a demotion order under section 82A. 2, in the case mentioned in subsection 1, capital A, little a, the tenancy ends when the order is executed. 3, where a secure tenancy is a tenancy for a term certain, but with a provision for re-entry or forfeiture, the court should not order possession of the dwelling house in pursuance of that provision, but in a case where the court would have made such an order, it shall instead make an order terminating the tenancy on a date specified in the order, and section 86, periodic tenancy arising on termination of fixed term, shall apply. Subsection 4, Section 146 of the Law of Property Act 1925, restriction on and relief against forfeiture, except subsection 4, vesting in under lessee, and any other enactment or rule of law relating to forfeiture, shall apply in relation to proceedings for an order under subsection 3 of this section, as if they were proceedings to enforce a right of re-entry or forfeiture. Lord's common ground that the words forfeiture and re-entry are interchangeable, and for simplicity I shall refer to them as forfeiture. Ground 1 of this appeal breaks down into 2 linked questions of statutory interpretation of Section 82. The first question is, what is the correct meaning of the words in subsection 1b, subject to termination by the landlord? The respondent contends, in agreement with the judge, Mrs. Justice Tipples, that these words mean termination by forfeiture alone. See judgment paras 12 and 51. Croydon's case, in respectful agreement with the Court of Appeal, is that subject to termination by the landlord means termination by any lawful means available to the landlord as a matter of contract. See the judgment of Lord Justice Arnold, paragraph 53. It would include, therefore, provision for termination by break clause or any other lawful means. Lord Justice Arnold lists 4 at paragraph 22 of his judgment, and would fall, needn't turn it up, at tab 42, page 924, lists others. That is not to say the tenancy could in fact be determined by a break clause. That's a separate issue. So that's the first limb of statutory interpretation arising under ground 1, the meaning of the word subject to termination by the landlord, and I shall refer to that as limb 1. And my Lord, the second question of statutory interpretation arising on ground 1 concerns the interplay between section 82(1)(b) and 82(1) capital A, little a, and little b. The agreed question set out in the Statement of Facts and Issues is whether Section 82 requires the landlord to exercise the forfeiture-style route to termination under Section 82(3) before it can seek to recover possession from the fixed-term tenant on the statutory grounds before the natural expiry of the term. The respondent says on that it must, and on that question the Court of Appeal agreed with her, see Lord Justice Arnold's judgment at paragraph 63. Consequently, unless the landlord has both a forfeiture clause and forfeiture grounds on which to obtain a termination order under Section 82 subsection 3, it cannot apply for possession during the fixed term of the secure tenancy on these statutory grounds. It's locked in. Croydon's case on this second limb is that the landlord who falls within 82(1)(b), tenancy subject to termination by the landlord, may apply during the fixed term of the secure tenancy under Section 82(1) capital A, little a, for a possession order against the tenant on the statutory grounds, and that the need for a termination order under Section 82 subsection 3 only arises where the landlord wishes to exercise forfeiture rights. Well, on that question, the judge agreed with Croydon, see paragraph 61, but the Court of Appeal disagreed. That's the second question of statutory interpretation arising from ground 1. I shall refer to it as limb 2. Turning to ground 2 of the appeal, this raises a question of contractual interpretation. It asks whether any of the terms of the respondent's flexible tenancy agreement should be construed as a forfeiture clause, as defined by the Court of Appeal in Clays Lane Housing and Patrick. It's common ground, my Lord, that Croydon did not seek to forfeit the respondent's flexible tenancy. Consequently, and as recorded in the SFI, ground 2 only falls for decision in limited circumstances. So if I could set out the possibilities here, if this court were to agree with Croydon on both limbs of ground 1, then Croydon would not need a decision on ground 2, as the only question then would be whether the statutory grounds are made out. It's agreed that this contract, this tenancy, would be otherwise subject to termination by the landlord. That agreement is recorded in the SFI. So only that matter need be remitted to the county court on the claim whether the statutory grounds are made out. If this court were to dismiss Croydon's appeal on the second limb of ground 1, success on ground 2 would not assist Croydon in this case because it didn't seek to forfeit, although of course any opinion that this court felt that it was able to give on ground 2 would be beneficial not only to Croydon but to other local authorities who have no doubt looked at the Court of Appeal's judgment and their own tenancy conditions, wondering which side of the line they lay on. Well, the third possibility is that this court dismisses Croydon's appeal on the first limb of ground 1 but allows it on the second. In other words, comes to the same conclusion as the judge, that you need a forfeiture clause, but provided you have it, you don't have to rely upon it. In those circumstances alone, the ground 2 falls for decision. Well, Lord, I hope that's clear, and the way that the issues are laid out. In any event, it's agreed that whatever the outcome, the claim should be remitted to the county court, either for determination of the claim in the way that I've said, and counterclaim, or for the counterclaim alone.
Mr. Rutledge, I may be wrong, but I'm assuming that, bearing in mind that the fixed term in this case has, I think, now expired.
Yes.
So there will be nothing to stop Croydon seeking possession in the usual way on the footing that the tenant is a periodic tenant, because the fixed term having expired by a fraction of time.
Yes.
Really, all the issues in the case are, as it were, being dealt with at this level to assist local authorities and their tenants in a wider sense, rather than because they're essential to resolve the question whether the respondent stays in occupation of this dwelling house.
Lord, yes, respectfully, that's absolutely right. None the worse for that.
None the worse for that, I hasten.
None the worse for that.
Not because it's a case about costs, it's a case about real issues affecting numerous local authorities and thousands of tenants.
This is the first case to look at the interplay between these sections since they were enacted in 1980, and it's particularly important for that reason. The Lord has seen from the background material the number of flexible tenancies that have been granted. It's a wide-scale problem. I did put my case specifically on that basis.
It's not limited to flexible tenancies, though. I think you started by saying it applies to any form of secured tenancy.
Yes, not
where there is initial term certain.
Lord, yes, I made that point earlier.
Yeah.
It's not just the flexible tenancy scheme has made more popular the use of fixed term tenancy, so it's now perhaps a problem that might not have arisen earlier. Lord, by way of, but that, with respect, that's absolutely right. I'll deal with it later, but Lord will see that the statutory process by which the flexible tenancy is brought to an end has been challenged in separate judicial review proceedings, on which there has been a High Court judgment in favour of Croydon, but that's subject to an extant appeal to the Court of Appeal, for which the judge granted permission. I'll deal with that in due course when I just pick up on the facts. By way of roadmap, I propose to present the argument in these parts. Part 1, the statutory scheme for secure tenancies, briefly, my Lord, because of the clear and helpful way in which it was laid out in the judgments below. Secondly, Part 2, similarly, the facts, again briefly and really by way of identifying relevant documents, and I will take that as quickly as I can. Thirdly, to present Croydon's submissions on the 2 limbs of ground 1, and fourthly, and again I think briefly, the submissions on ground 2, if that's helpful. Lord, can I begin please with the statutory scheme? The judge sets this out at paras 24 to 42 and the Court of Appeal at 14 to 21. Can I just begin with a few words about background? And paras 12 to 14 of our case, we set this out, although an altogether more authoritative statement is from Lord Newberger in the Knowsley Housing Trust and White case that we footnote at 10. But prior to 1980, public sector tenants enjoyed no security of tenure, no statutory security of tenure. Tenancy agreements were governed by contractual rules. They had, I think Lord Denning described, de facto security, but decisions were to evict were susceptible, in theory at least, to no more than a Wednesbury control of the exercise of power. Public sector tenants were, however, afforded some rights under the Protection from Eviction Acts. And can we look, please, at the latter and current Act, which is at tab 3, page 283. Well, Lord, I'm working from hard copies, so I want to make sure that Lords, my lady, are able to get to the documents. They'll probably be there before I am, but just...
But you're giving us electronic page numbers.
I'm going to give you tab numbers and page numbers, if that helps.
Yes.
So what we have here is the Protection from Eviction Act 1977. which applies to all residential tenancies, including those of local authorities. Section 2, restriction on re-entry without due process of law. Where any premises are let as a dwelling on a lease which is subject to a right of re-entry or forfeiture, it should not be lawful to enforce that right otherwise than by proceeding in the court, while any person is lawfully residing in the premises or part of them. So you can't exercise a forfeiture right by physical re-entry when there's residential occupation, as will invariably be the case on a secure tenancy because of the condition that the tenant must occupy as their only or principal home. So that was the first protection. But 1977 saw the publication of the Green Paper, Housing Policy, a consultative document, which proposed the introduction of statutory regulation in the public sector. We have excerpts from that Green Paper in the bundle. Can I invite the court, please, to turn to tab 34, page 861.
While we're going there, is there any reliable information before the court about the extent to which local authorities were granting fixed term rather than periodic tenancies before the 1980 Act was passed?
Purely anecdotal. We've not found any reliable information to that effect.
No, but it would have been useful by way of background in a way. One assumes they must have been, otherwise there wouldn't be detailed provision about them in the Act, but maybe it was just there out of caution.
Again, anecdotally, or picking up from cases, although we found very few cases, even before 1980, of fixed-term tenancies in the public sector. To be fair, if we had, they'd probably be in the bundle as an illustration. But they clearly were, because they were picked up by the 1980 Act.
Yes.
Of course, my Lord's point, but to answer your Lordship's question crisply, no. We have no reliable information. So what we're looking at here is the 1977 Green Paper, Housing Policy, a consultative document. And the Lord will know that the 1980 Act introduced not only security of tenure for public sector tenants, but also the right to buy with it. So a lot of the Green Paper is about that. But I'd just like to show the court at page 866, chapter 11, housing tenure. And then at the foot of that page, there's the heading, A Tenant's Charter. And then over the page, this is page 867, the subheading Public Sector Tenants. 1106, some local authorities impose on their tenants complex rules and regulations which lay down obligations, often on comparatively detailed matters, but few give rights in return. The government therefore proposes to introduce a tenants' charter, developing a code of principles and practices for local authorities in new town tenancies, much of which will be relevant to the housing association. And in 1107, security of tenure, the right to a written agreement. At present, the lack of statutory security of tenure is the most important respect in which the public sector tenant position falls short of that of the tenants in the private sector. Local authority and new town tenants already enjoy a high degree of security in practice, and the government proposes to introduce legislation giving statutory recognition of this de facto security. The special position of responsibilities of housing authorities will be recognised in drawing up the statutory grounds on which possession can be attained. The government also believes the public sector tenants should have a statutory right to a written tenancy agreement. Well, look, I'll come back to that later when we invite the court to take a purposive look at the section. But can I at this stage just lay down a marker? There appear to be two policy initiatives there. On the one hand, to make sure that tenants of local authorities and other public sector landlords have proper security of tenure over and above their contractual rights. But secondly, it's to recognise the special position of local authorities in managing their accommodation and having statutory grounds of possession. Lord, there's a footnote to that which refers to a report of the Housing Services Advisory Group, Department of Environment, May 1977. And we put a footnote in our case which seeks to summarise, it's our footnote 12
At page?
of our printed case.
Yes, but what electronic page are you on?
I'm sorry?
In your printed case?
In our printed
I'm looking at on an electronic screen.
Yes, I'm sorry, yeah.
Do you have an electronic page number for the page?
Oh, I'm so sorry. I do apologise. Page 46.
Thank you.
I'm sorry.
That's right.
I have it separately, and I didn't think. Page 46, we footnoted the product of Mr. Calzavaro's researches at the National Archives Centre in Kew to go through the 700 odd pages of that working group of documents. But as the note says, there was nothing in it concerning, one way or another, concerning the termination of the tenancy. So, I'm sorry, mate.
No, I didn't mean to interrupt. We're at the end of the sentence. All I wanted to point out, it does appear from what you've shown us at 866, and also this footnote, that it was a policy aim to ensure parity between private sector security and public sector security. I'm nodding.
It was, but we'll come to Lord Hoffman on that in a moment.
All right. But could we have the link to the whole of the Green Paper? Because I can see there are chapters dealing with what was perceived to be the security in private housing, to which, on this basis, some analogy was to be drawn.
I would like to offer a link. We couldn't find one. I acquired it in hard copy, which I'm very happy to lend to the Supreme Court Library for the purposes of this case. Well, I obtained this, my lady, through a very special source known as eBay. It's the only place I could find. Not even Lincoln's Inn Library could provide it to me.
It's not on the departmental website.
We couldn't find it.
And have they sent it to Kew?
We'll look again and try to stipulate on that. We'll put that on the list. The first thing, the electronic link to that. We find it now.
Yes, it's really important.
We missed it first time round, but we, in any event, lady will have it in hard copy.
Thank you very much.
But sadly, not part two. That wasn't available. There is a technical volume that goes with this as well.
Yes, of clauses.
So we haven't trawled through that.
Right.
Yes.
Well, thank you. And it is really important on statutory interpretation that we can find these documents. And I'm sorry if there's a gap between the departmental website and National Archives. There shouldn't be.
Yeah. Yes. Yeah. Well, we've done what we can in researching the background. Our friends have done the same thing, trying to assist the court, but it looks like a blank sheet of paper. There was no white paper before Parliament. We've set out in our case the history of the passage of this bill through Parliament. Clause 5 of the bill, they shuffled around the bill. They had security of tenure at the early sections, followed by the right to buy. And then when the Act came out, right to buy came in first. Sorry, the other way round.
Did they not publish summary of responses to consultation?
We haven't found that either.
Right.
We have, I'm afraid, drawn a blank.
Right. Maybe then.
It's not without effort, my lady. Equally with Hansard, because I was saying clause 5 of the bill, the original bill, which had its first reading in January 1980, that is now what we look at in section 82 materially. There have been updates, demoted tenancies and things like that, but essentially the words that this court is invited to construe appeared in the same order, pretty much, in the original bill, clause 5. That went through without any recorded amendment or debate, and in particular including Standing Committee F, which ordered it simply to stand as part of the bill. So we can find no background discussion or debate at all. It subsequently became section 32, and I shall be inviting the court to look at that in due course. The Court of Appeal based its analysis on section 32, which was the predecessor to what is now section 82. And so the Housing Act 1980 received royal assent on the 8th of August 1980 and materially came into force on the 3rd of October 1980. So can we just have a look, please, at the Housing Act 1980? I'll come back to it, but I just want to, by way of
Just before we do, are you going to be maintaining a submission that differences in the language between the 80 Act and the 85 Act actually help us construe the 85 Act, or not? I'm not doing that to try and fend off the 1980 Act at the pass, but I just want to know what we're looking for in it. Are we looking at subtle differences in language which give a guide to the interpretation of the 85 Act, or is it simply because it came first, so we're starting there?
We're looking at it primarily because the Court of Appeal looked at it.
Well, I know.
And the Court of Appeal's analysis is based on the 1980 version. I don't think we go as far to say that there was a sea change in later statutes. What we will say is that by the time we get to our modern day version, the one I read at the outset, it's much clearer. We have a list. We have a list of optional alternatives. So we say that that's helpful in understanding the original meaning of the section. But, Lord, with greatest respect, the task for this court is to construe Section 82 of the Housing Act as it stands.
Yes.
So obviously I will make submissions based on that, but I have to go to the 1980 Act, not purely for historical reasons, but because the Court of Appeal went there.
Also, it's clearly relevant, isn't it, to the interpretation of the 85 Act? And so it's part of the context in which Parliament enacted the 85 Act.
Yes.
So it's clearly relevant and
Yes.
useful.
So can we go, please, to tab 4, page 285. Which is the Housing Act 1980, and if we turn to 293, we see the long title, An Act to Give Security of Tenure and the Right to Buy Their Homes to Tenants of Local Authorities and Other Bodies. And then just to note briefly at this point, two sections. Firstly, at page 296 is section 32. So that's the predecessor of our section 82, and that's the section the Court of Appeal construed. And then secondly, can we note, please, section 47 at page 305, section 47, application to existing tenancies. This chapter applies to tenancies granted before, as well as tenancies granted after the commencement of this chapter. So it was retrospective. We've put a case in the bundle called Harrison, which considered that whether a tenancy which had been terminated lawfully, contractually, before the Act came into force was caught by the legislation. The answer, no. But otherwise, existing tenancies were. And we say that that's an important feature in terms of analysing this legislation.
We need section 29 as well, don't we?
Lord, I'm going to come back to this.
Okay.
What I don't want to do is jump between the two acts all the time and confuse myself, if not.
But I mean, before we leave the 1980 Act, section 29 is part of the central.
Yeah, yes, of course. Well, section 29 is what is now 86.
Yes.
And that puts in place a statutory periodic tenancy in two circumstances: expiry by effluxion of time and a termination order.
And it is, I hope, and partly Lord Hoffman, common ground that it is a form of statutory tenancy.
There's a statutory tenancy there. There are one or two under the 85 Act. We'll see in a moment. We'll also ahead of me, but we'll see in a moment. It's all contractual, except one or two cases where Parliament puts in
and this
statutory.
This is one.
Yes.
Yes.
We've mentioned the Housing and Building Control Act 1984, which introduced 3 new grounds of possession. And then we come to the 85 Act, which is at tab 7, page 325. So we're now looking at part 4, well, the Housing Act 1985 at page 325. And we see from the heading, it's an act to consolidate the housing acts except those provisions consolidated in the Housing Associations Act and the Landlord and Tenant Act 1985, and certain related provisions with amendments to give effect to recommendations of the Law Commission. And that was the 1985 Law Commission report on the consolidation of the Housing Acts. Again, that's been looked at, and nothing that in there that appears to be of any assistance in this case.
That would presumably be the report on the consolidation bill. There would be one preparatory to the consolidation bill.
Yes, there would have been. I don't think we've looked at that. We'll make a note. Thanks.
But insofar as it was to, I mean, it might be of some help that the Law Commission's recommendations are silent on the key issues, in the sense that otherwise it's a consolidating act. You know, I mean, from what you say, there's nothing that helps in the Law Commission's recommendations, which I think I take you to mean the Law Commission wasn't saying, for example, that anything in the key provisions of the 1980 Act with which we're concerned needed to be changed or clarified.
My Lord, that's right, but I think my Lord's taking it one stage further and saying that something might be inferred from the fact that there's no mention.
But the recommendations described in this long title are those very technical amendments which the Law Commission proposes to Parliament at the time of consolidation, where it's in fact a possibility that it's slightly changing the law and therefore needs to be brought to the attention of Parliament. It's not a normal law reform report, so it'll be a separate document.
Well, my lady, we don't have that report.
The Law Commission should have it. The Law Commission's done a lot of work on housing.
Yes.
So I hope they've got it.
We can furnish the court with the Law Commission's report, if that would help. Well, perhaps over the short adjournment, we'll see what we can find in that, lady. Sis. Now, I needn't take the court to it, but paragraph 18 of our case, we talk about a new approach to regulation. And we make the point that although the 1980 and the 1985 Act sought to assimilate the rights of public sector tenants with those enjoyed by the tenants in the private rented sector under the Rent Acts, the means by which the 1980 and 85 Act sought to achieve this was quite different. And we refer the court on that to Lord Hoffman in Birmingham and Walker, tab 19, page 599. Birmingham Walker was a succession case, and at page 603 of the bundle, paragraphs 2 and 3 of Lord Hoffman's speech. Until the passing of the 1980 Act, tenants of local authorities and similar public sector landlords had no security of tenure. They were excluded from protection under the Rent Act. Part 1 of the 1980 Act conferred 2 benefits upon public sector tenants. Chapter 1 gave them the right to buy the freehold, if it was a house, and a long lease if it was a flat of the dwelling, at a discounted price and left outstanding on mortgage. Chapter 2 introduced the concept of secure tenancy for public sector tenants. The secure tenancy, like the statutory tenancy in the private sector, can be terminated only by an order of the county court made on one of the lists of specified grounds. But the technique by which secure tenancies are integrated into the ordinary law of landlord and tenant is very different from that which was used in the Rent Acts more than 60 years earlier. The old legislation had left untouched the landlord's right to determine a contractual tenancy by notice or otherwise in accordance with its terms and the general law. It provided that on such termination, the tenant acquired a new interest, which is now called a statutory tenancy. The 1980 Act, on the other hand, preserved the contractual tenancy. It merely added statutory incidents to the tenancy which overrode some of the contractual terms. These overriding provisions include the provision which prevent it from being terminated except by an order of the court on the statutory grounds. So a broad policy to assimilate the rights of those in the public sector with those enjoyed in the private sector under the Rent Acts, but by a different technique. primacy of the contract.
That's an obviously correct description of a secure tenancy that started out in life as a periodic tenancy. But is it a correct description of a secure tenancy that starts out in life as a fixed-term tenancy, whereas we've seen when it expires by fluxion of time or forfeiture, it is replaced by a form of statutory tenancy?
My Lord, no. I accept Lord's point that there is something that might, in very broad terms, be likened to a Rent Act statutory tenancy, because there are certain circumstances, my Lord's identified one, where the Act itself imposes a tenancy, but it takes its terms from Section 86 makes this clear. It takes its terms from the previous contractual tenancy, except any forfeiture provision. And Lord, this contractualisation of leases, as Professors Gray and Gray describe it in their book, Elements of Land Law, owes much to the development of the law over the years relating to secure tenancies, not least the landmark decisions, which we put in the bundle simply for background reading, of Hammersmith and Fulham and Monk, and of course London and Quadrant Housing Trust and Bruton, two decisions of immense importance of the House of, and practical application of the House of Lords. So, my Lord, can I please invite the Court just to look at some of the main provisions of Part 4 of the 1985 Act? And could we please go to tab 7, page 325. I'm really just going to highlight the scheme in general terms and pick out one or two particular. As I say, both judgments below set out the scheme with clarity, so I don't propose to spend too much time on this. But if we could start, please, with section 79, which is the first section in part 4 of the Act, and it defines secure tenancies. And can I please invite the Court to make a note that when later we look at section 117, the definition section, that takes us back to this section. So when the Act talks about a secure tenancy, it's referring to one as described in section 79. 79 says, I shan't read it all, 79.1, a tenancy under which a dwelling house is let as a separate dwelling is a secure tenancy at any time when the conditions described in sections 80 and 81 as the landlord condition and the tenant condition are satisfied. Then subsection 1 has effect subject to exceptions in shed 1, tenancies which are not secure. And then subsection 3, the provisions of this part apply in relation to a licence to occupy a dwelling house, whether or not granted for consideration as they apply in relation to a tenancy. So the tenures that this covers include a periodic tenancy, a fixed-term tenancy, non-proprietary Bruton-style equivalents of those, a periodic licence and a fixed-term licence. They're all caught by this single definition. We turn, please, to page 327. We see the first of those conditions, the landlord condition. The landlord condition is that the interests of the landlord belong to one of the following authorities or bodies. First one is a local authority. And then page 333 is the tenant condition, section 81, the tenant condition. The tenant condition is that the tenant is an individual and occupies the dwelling house as his only or principal home, or where the tenancy is a joint tenancy, that each of the joint tenants is an individual, at least one of them occupies the dwelling house as his only or principal home. And then at page 336, we have section 82 that I've read. Then at 338, we have 82 capital A, which was an addition additional provision, I'll come on to that later, for demoted tenancies because of antisocial behaviour. And then section 83, it's an important section for our purposes at page 342, Section 83, proceedings for possession or termination, general notice requirements. Section A1, this section applies in relation to proceedings for an order as mentioned in 82(1) capital A, other than certain exceptions. 1, the court shall not entertain proceedings unless the landlord has served a notice on the tenant complying with the provisions of this section, or the court considers it just and equitable to dispense with the requirements of such a notice. 2, a notice under this section shall be in a form prescribed by regulations made by the Secretary of State and specify the ground on which the court is asked to make the order and give particulars of the ground. And can I just go over the page, please? 343, subsection 6. Where a notice under this section is served with respect to a secure tenancy for a term certain, it has effect also with respect to any periodic tenancy arising on the termination of that tenancy by virtue of section 86. And subsection 3 to 5 of that section do not apply to the notice. And 7, regulations made under this section should be made by statutory instrument and may make different provision with respect to different cases or descriptions of cases, including different provisions for different areas. I shall be inviting the court in due course to look at those regulations. We'll then go, please, to page 355, which is section 84, grounds and orders for possession. The court shall not make an order for the possession of a dwelling house let under a secure tenancy except on one or more of the grounds set out in Schedule 2. And then 2, the court shall not make an order for possession on grounds 1 to 8 unless it considers it reasonable to make the order. 9 to 11, unless it's satisfied that suitable accommodation will become available for the tenant, and 12 to 16, unless it's satisfied that both those conditions are met. And then there's 84A at page 357. There's an absolute ground for possession in antisocial behaviour cases to deal with the most serious cases. And then at 360, we have section 85, extended discretion of court in certain proceedings for possession. I'll come back to this in due course, but essentially this gives wide powers to the court on in possession proceedings to adjourn, stay, suspend the proceedings or the order made on terms or otherwise. And then section 86, page 365. We looked at this briefly in the, as it appeared in the 1980 Act, periodic tenancy arising on termination of fixed term. Where a secure tenancy, the first tenancy is a tenancy for a term certain and comes to an end by a fluxion of time, or an order under section 82(3), termination in pursuance of provision of re-entry or forfeiture. A periodic tenancy of the same dwelling house arises by virtue of this section unless the tenant is granted another secure tenancy of the same dwelling house, whether a tenancy for a term certain or periodic tenancy to begin when they come to the end of the first tenancy. Where periodic tenancy arises by virtue of this section, the periods of the tenancy are the same for those for which rent was last payable under the first tenancy, and the parties and the terms of the tenancy are the same, except that the terms are confined to those which are compatible with the periodic tenancy and do not include any provision for re-entry or forfeiture. Madam Law, can we go please to section 102, which is at page 396, variation of terms of secure tenancy. The terms of a secure tenancy may be varied in the following ways, but not otherwise. By agreement. B, to the extent the variation relates to rent or other payments, by service of a notice of variation. Or C, in accordance with section 103, notice of variation of periodic tenancy. And I mention that because in our case, we make the point that without the consent of the tenant, a local authority cannot amend its fixed-term tenancy agreement to write in a forfeiture clause and rely on the judgments below. And that's part of the difficulty that we're facing. We then go, please, to page 407. And we have here a mini scheme introduced by the Localism Act dealing specifically with flexible tenancies. Lord, I don't know to what extent it will assist if I go through all these sections. Perhaps what I do is simply highlight what each section does, and if necessary, we'll come back to them. But section 107 capital A tells us what flexible tenancies are and how they're created by notice. Section 107B gives the prospective tenant a right to request a review in advance of the offer of a flexible tenancy. 107C, which is at 411, gives the tenant under a flexible tenancy the right to serve notice to quit if not in breach. Section 107D gives the local authority the right to recover possession at the end of the fixed term, subject to service of statutory notices. That section, as per subsection 10 at the top of page 413, is without prejudice to any right of the landlord under a flexible tenancy to recover possession of the dwelling house let on a tenancy in accordance with this part. And then finally, at page 416, section 107E, review of decision to seek possession. So if the local authority serves its statutory notices that at the end of the term it intends to seek possession, the tenant has the right to request a review. There's a 21-day period for that under 107E1. And just to inform the court, in this case, that period expired without a request for a review. A review came later, and the question for Mr. Justice Kavanagh was whether there's power in the local authority to extend that 21-day period, and His Lordship held that there was not. But as I've indicated, His Lordship granted permission to appeal, and that matter is pending before the Court of Appeal. So that's the judicial review point in this case. And then section 117, which is at page 434, is that definition section I mentioned earlier, or rather index of defined expressions. And when we scroll down to see secure tenancy, we're directed back to section 79. So the way this Act defines secure tenancy is by way reference to section 79, which includes all those tenures that I had listed earlier on, including periodic and fixed term. And then I'll come back to it, but just to mark it up at this stage, at page 437, we have Schedule 2, which sets out the statutory ground. Lord, I'm afraid the way that it comes off, I think, Westlaw,
I know.
We have to look at the bottom.
It's a beast. And I was wondering if there was any shortcut to scholarship in the terms of a more conveniently set out list of the grounds for possession.
Yes.
Because it's a very inconvenient document to work one's way through.
I know, but I do need, when I come on to my submissions, I do need to look at some of the grounds.
Indeed. Yes, I can understand that. I was just hoping there was an easier list. Does Woodfall list the grounds in a convenient form? If nothing else, on one page.
Mr. Galzavar is going to run up a list for us.
Thank you. That would be really helpful.
Yes.
No doubt you'll show it to the other side just to make sure it's approved as text. But at the moment, having to trawl through
I know.
multiple pages with 2 relevant lines on each page is quite a task. Oh, I'm sure you found it to be as difficult as well.
I had more time than Lord's got now to do it, but yes, we'll do that. But I do need to come back because
I understand.
I wondered if there was an option on the printing out in the Westlaw format to take the notes out. There are different options. But anyway,
yes.
Perhaps somebody's thought of that.
We'll look at that, see what we can do.
If it's possible.
Or on the legislation website,
Yeah.
the government website might have a better version.
Can I then just finally, on the statutory scheme, take the court to the two sets of regulations. Tab 15, page 526. To save time, I'm not going to read them all because they are quite important to the argument. This is now presented in the respondent's printed case. But if we start page at 526, this is the SI that was published under the 1980 Act for the Secretary of State or the Secretaries of State to prescribe forms. And
these were published before the Act came into force?
Well, they were made on the 4th, before they came into, yes, my lord, the answer is yes, but after the Act was passed.
Yeah.
We see these regulations may be cited. Then 2, the notice to be served on a secure tenant under Section 33 before the court can entertain proceedings for possession of a dwelling house let under a secure tenancy, which is a periodic tenancy, shall be in the form specified in Part 1. And then 2, the notice to be served on a secure tenant under Section 33 of the 80 Act before the court can entertain proceedings for the termination of a secure tenancy, which is a tenancy for a term certain, and for possession of the dwelling house let under that tenancy, shall be in the form specified in Part 2 of the schedule of these regulations, or in substantially the same effect. I'll come back to that. The importance of the word that might shed some light on the Secretaries of State understanding of the scheme at that stage. That is repeated in the 1987 regulations, which we find at page 532, which are in similar form. And these, my lord,
sorry, page
532.
Thank you, I missed the 2.
And these are still the current regulations. So I'll come back to that in due course. Lord,
Did these come into force at the same time as the 1985 Act?
No.
Or did everybody continue to live on the 1980 regulations for a couple of years?
the 87 regs revoked the 80 regs.
Yes, but...
So they carried on.
Yes, one would have thought. So everybody carried on quite happily under the 80 regs when the 1985 Act came into force?
Yes, for 2 years.
Fine.
Yes. Can I come then to Part 2, the facts? And I do propose to take this briskly, save time. Again, by way of reference, the judge sets it out at paras 1 to 17, and the Court of Appeal 1 to 13. And of course, the court has the parties' statement of facts and issues.
Yes.
My Lord, the first thing I must do is take the court to page 36, which is the parties' agreed note.
Oh, yes.
As Lord Read, I can only apologise for that. I don't know quite where things went wrong, but thankfully the terms were not materially different, the ones that the Court of Appeal looked at, but we are now going to look at the correct tenancy terms in relation to this. So if we look, page 139 is the flexible tenancy agreement. I don't propose to read all these documents, simply don't have time to do that, but Lord say at the top, by signing this agreement, you are confirming you agree to the terms and conditions of the flexible tenancy agreement, which are set out in the conditions of tenancy booklet. You should read the booklet carefully, and so on. And I'm not going to read out personal details in relation to the tenancy, but they are laid out there. And then we have the conditions of flexible tenancy. Well, I think I can take this fairly quickly for this reason. If we look, please, at page 144. A third of the way down the page, it says this is after reasons for seeking possession. We may also take eviction action at any time if one or more of the grounds for possession set out in Schedule 2 of these conditions apply. And the purpose of Schedule 2 is to summarise those statutory grounds that we find in Schedule 2 to the 1985 Act. It's common ground in this case that that clause, that provision there, would be sufficient to bring this tenancy within Section 82(1) little b, subject to termination by the landlord, if this court finds, in accordance with the Court of Appeal, that those words are not limited to termination by forfeiture. But insofar as it's necessary for me to lay the factual foundation for my ground 2, we rely on that provision. We rely on clause 3, which is at page 150.
Okay, can I just check, Mr. Rutledge? This being a flexible tenancy, am I right in thinking that at the end of the 5-year term, it doesn't morph into an ordinary statutory periodic tenancy, does it? Or does it?
Yes, it does.
It does.
A flexible tenancy, we see, it's my fault because I raced through the 107 provisions. A flexible tenancy is a secure tenancy.
Yes.
So Section 86 would apply in any event, unless the statutory procedure that is described in Section 107, the notices procedure, brings it to an end. So there are rules grafted on it. It's an ordinary secure tenancy, fixed-term tenancy, with additional rules
About how it can be terminated.
Yeah.
Yeah. Okay.
Clause 3, ending your tenancy 150, your or joint tenant may end a tenancy at any time. An action by us, we may end a secure tenancy by first serving a notice seeking possession and applying to the court for an order of possession. Minimum period of notice seeking possession varies depending on the grounds. If you or someone else remains in occupation after notice period, we will seek a court order for possession. And then clause 10, which is at page 153, grounds upon which we may seek possession, or if you break any of the terms, break any of the clauses of this agreement, or if any of the grounds in Schedule 2 to the Housing Act as amended applies in the future are breached. A summary of the grounds set out in Schedule 2. That was the tenancy agreement. Then at page 209, we have a letter, 2nd of August 2017, from the Antisocial Behaviour Enforcement Officer to the Respondent, serving notice seeking possession. And I should just draw the Court's attention to the 3rd paragraph. The attached notice is served without prejudice to Croydon's argument that it does not need to terminate your tenancy by exercising a provision of re-entry or forfeiture. We appreciate that the first bullet point of Section 2 suggests otherwise, but Croydon is of the opinion that those words of the notice, which was drafted in 1987, are now obsolete in the light of the flexible tenancy scheme under the Localism Act 2011 that applies to your tenancy. And then we get the Part 2 form, notice seeking possession, at page 210, and then overgo the page, it particularises the breach. Then we go to the claim form, page 217, and we see at the top, under grounds for possession, rent arrears, other breach of tenancy are ticked, forfeiture of the lease is not ticked. So as I made clear earlier, Croydon wasn't seeking to forfeit. And if I could just pick up at 220, para 6, these are the particulars of claim. Para 6, the appropriate notice seeking termination was served on the defendant on 2nd of August 2017. The reason I refer to that is because we now go to the defence and counterclaim, which begins at 223. There's a detailed defence that goes into the claim based on, amongst other things, the Equality Act, and the Human Rights Convention. And then this at para 23, page 228. This pleads to that paragraph in the particulars of claim that refer to the notice seeking possession. It says it's denied, and the defendant will aver that the claimant is unable to rely on the same. The conditions of tenancy do not include a forfeiture proviso. Further alternative, the claim has failed to serve a 146 notice. Further alternative, claim has waived the rights, and so on. And then towards the bottom of that paragraph, page 229, further and alternatively, there was not a reasonable period of time between the service of any notice, which is not admitted in the issue of proceedings, and then this, further and alternatively, the claim for possession is defective as a claim for possession of a secure, flexible tenancy during the fixed term. So there, the tenant, the respondent, is taking a wide range of points, issues, including the assertion that the flexible tenancy cannot be determined during its term. And then there's a counterclaim for disrepair and breach of the Equality Act. And then the reply and defence to counterclaim, can I just pick up at page 240, para 10, as to para 23 of the claimant's, that's the paragraph of the defence we've just looked at, the claimant's case does not rely upon forfeiture. My Lord, the background or the chronology is set out in the documents. The respondent asked for the case to be transferred to the High Court. His Honour Judge Bailey part transferred it for determination of a preliminary issue which the judge sets out. Parties agreed the correct manner in which to determine a secure, flexible tenancy during the fixed term, including whether, and if so, how, any principles relating to forfeiture apply. And then that matter came before the judge remotely on the 8th of April 2020, and the claim for possession was dismissed, orders and declarations were made, and unless the court wishes me to do so, I'm not going to take it to the two judgments, but I will in due course just pick out points where we make submissions and save time. Lord Justice Floyd granted permission to the Court of Appeal, and that was heard on the 15th of December, judgment on the 27th of January. The current situation, insofar as it's necessary to understand, is that the, as Lord noted, the flexible tenancy expired by a fluxion of time on the 24th of May 2020. The attempt, Croydon's attempt to seek possession were challenged in the judicial review proceedings. So far as Croydon is aware, the respondent is now back in fiscal occupation. There are, I'm instructed, still some rent arrears, but no recent reports of antisocial behaviour. I just mentioned that by way of update. So, my Lord, may I please turn to part 3, and that's Croydon submissions on ground 1. Can I just offer an overview of the two limbs and then address them in turns? So an overview of Croydon's case on section 82, both limbs, is this. First of all, respectfully, my Lord Briggs' point, as regards fixed-term secure tenancies, section 82 has to be read in conjunction with section 86. Clearly, the two sections sit together. We submit that section 82 is the manifestation of that policy objective that I referred the court to in para 1107 of the 1977 Green Paper, namely statutory security of tenure and a guarantee that a tenant cannot be evicted from their home except on statutory grounds. That's the absolute guarantee under this legislation. If you're a secure tenant, you can only be evicted on statutory grounds, and a number of the grounds require the court, as we've seen, to consider that it is reasonable and or that alternative accommodation will become available. We say that Section 82, when read in conjunction with Section 86, achieves that policy objective in three ways. First, where the fixed-term tenancy comes to its natural end, a periodic tenancy replaces it, from which the tenant can only be evicted on statutory grounds. So protection there. Back in 1980, Parliament wanted to give protection to public sector tenants. In relation to periodic tenants, all Parliament had to do was to provide that service of a notice to quit would have no impact, no effect. But the problem with a fixed-term tenancy is it ends. So provision was made in what is now Section 86 for the carry-on statutory periodic. So that's the first way that it achieves that policy objective, by ensuring that when the fixed term ends, a periodic tenancy replaces it, from which the tenant can only be evicted on the statutory grounds. Secondly, where the landlord wishes to forfeit the tenancy, and bearing in mind Section 47, there would have been, or at least might have been, fixed-term tenancies in place with forfeiture clauses.
Well, that's why I was asking, yes.
Yeah. In theory, at least, my lord, yes. There would have been. It can only do so, where the landlord wishes to forfeit, it can only do so by obtaining a termination order. Forfeiture, in fact, is overridden by this Act. It's replaced with a termination procedure. Whereupon, again by virtue of Section 86, a periodic tenancy replaces it, from which the tenant can only be evicted on statutory grounds. Each way leads to statutory grounds, is our point. And the third way that it achieves the policy objective is where the landlord has some other contractual right to terminate the tenancy before its natural expiry date, such as a break clause. The exercise of that right doesn't bring the tenancy to an end, but what it does is it puts the landlord in a position where it can apply for a possession order under Section 82(1) capital A little a, again relying on the statutory grounds. Now, what that formulation does, two things. Firstly, it recognises the full range of contractual rights vested in the landlord. Secondly, it gives absolute protection to the tenant, that the tenant can only be evicted on statutory grounds.
Does the contractual right have to correspond to the statutory ground?
Yes.
Are you saying yes?
Yes. Can I go?
That doesn't seem to be explicit in the legislation, but that's how you interpret it.
That's how we interpret it, yes.
What would be the implications of that?
Sorry, well, suppose you didn't have a contractual right to terminate because you wanted to redevelop property, for example. Yes. No right in the tenancy agreement.
I'm so sorry.
But the tenant is a week late paying rent.
Yes.
And you have a contractual right of termination then. You can't go to the court, or can you, and say, right, well, it's subject to termination for non-payment of rent, but actually the statutory ground I rely on is the need to redevelop.
I'm so sorry, my lord. Yeah. Yes, you can. On our analysis, you can.
You can do that.
If it's subject to termination by the landlord, it doesn't matter on what basis it's subject to termination by the landlord. All that does is it distinguishes it from a fixed-term tenancy which is not subject to termination. So you could have a tenancy that has no provision at all for termination during the term, and the landlord would be locked in, and we accept that. There's no need for the tenant to be protected in those circumstances because the contract protects the tenant. But if the landlord has a contractual right to terminate the tenancy during the term, that's the gateway, we say, on a proper analysis, a proper reading of Section 82(1)b to the list in 82(1) capital A to C, which includes the right to claim for possession. But Lord, if the local authority wanted to claim possession for redevelopment purposes, as long as it's got some right, contractual right, to terminate the contract early, it gets into, it puts itself in a position where it can make that application.
How does that actually work? Say you've got a redevelopment break clause which enables the landlord to give, say, 3 months' notice to terminate a fixed term early. Not on any particular date, it's a floating redevelopment break clause to terminate on 3 months' notice. So the 3 months goes past.
Yes.
And you say then the landlord, having given that notice and waited for 3 months, can apply for possession on one of the statutory grounds, I think you say.
Well, my lord, I think my lord's. I'm sorry for a minute.
Well, can I just check whether that's part of your submission?
That was my submission, but I think my lord's referring to a specific term of break clause.
Well, I'm just trying to give an example. So suppose you've got a redevelopment break clause, exercisable on 3 months' notice. It's a 5-year term, and 6 months into the term, the landlord gives the notice. So contractually, it would terminate in the 9th month of the 5-year term.
Yes.
Now, how does the Act actually work in that context? Does a statutory periodic tenancy come into existence? I think the answer must be no, because that's not one of the circumstances listed in Section 86.
No.
So what happens? That there's no periodic tenancy. If the fixed-term tenancy has been validly terminated by the contractual mechanism, then you don't need any grounds for possession because there's no secure tenancy.
No, it can't.
How does your approach actually work in terms of the mechanics of the Act?
The break notice would not end the tenancy. That's the point. Section 82 is perfectly
clear. It
clear.
Fixed term.
Well, but it doesn't. 82 makes it clear that the only way the tenancy can come to an end is by an order of the court and enforcement of the order of the court. All the break notice doesn't end the tenancy. All the break notice does is it brings the landlord within Section 82(1) little b that the tenancy is subject to termination by the landlord.
But you can't be better off, can you, under the statute than you would be contractually?
No, no, but
I mean, it wouldn't be right that you...
No, of course it wouldn't be right. I'm not contending that, my lord.
No.
So to answer my lord's point, any form of break notice, any form of contractual right to terminate the tenancy, all it does is it's the gateway under Section 82(1)b, the gateway to access to 82(1) big A, little a to c. So you can then apply. We know from Section 82 the tenancy, and the tenancy is the contractual tenancy, generally speaking, doesn't end until originally it was the date set in the order, but as Lady Arden Wells knows from the tolerated trespasser cases, that was changed to the date of physical eviction. That's the way the scheme works.
Yeah.
It's an unusual scheme, and trying to fashion a forfeiture clause in those circumstances is challenging.
I still can't see what machinery of the Act you point to that requires you to serve a 3-month break notice. Say you've got a development break clause on 3 months' notice. Where does the Act say that you must serve that notice before you can obtain an order for possession under 1A?
It doesn't.
A1, it doesn't.
Oh, no.
So can you seek an order for possession without serving a break notice?
If that means the contract is subject to termination by the landlord, yes.
But you don't have to serve the physical notice. All you have to say is, I have a contractual right.
Yes.
And the term is subject to that. But somebody who does not, who has a term without that contractual right, that's the person we're dealing with, and that doesn't appear to be provided for.
I don't know if I can assist further.
I'm just trying to see where the service of the break notice comes into the process of getting possession.
It doesn't.
But I thought you accepted that you can't be better off under the statute than you are under the contract.
What?
And under the contract, you have to serve the notice in order to get possession, and therefore, surely you have to do so under the contract, unless it's actually... I thought its object was to restrict freedom of contract, not to enlarge it to the statutory grounds.
Lord, I think, respectfully, I answered Lord in the right way, but it goes back to section 82(1)(b. In order to bring oneself within 82(1) A to C, the menu, the three possibilities, the possession order, the termination order, or the demotion order, the tenancy has to be subject to termination by the landlord. It doesn't say it has to be terminated by the landlord. It can't be. A break notice has no legal effect under this scheme.
So the mere existence of a break clause, you say, makes it subject to termination by the landlord?
Mere existence of a break clause makes it subject to termination by the landlord.
So then you say you can go under 1A(1) for an order for possession?
Yes.
And all you have to do is to satisfy the statutory ground for possession?
Yes.
Which could be a different statutory ground.
Notice? I mean, take the development ground. I forget which one it is.
10 and 10A.
I'm not sure it requires you to serve a 3-month notice. But say the contract did. Are you saying that the mere fact it contains a break clause means that you can then exercise your rights under 1A(1) regardless whether you've actually served a break notice or not? And regardless of the fact that the notice, that the particular ground for possession, the redevelopment ground, is tougher on the tenant than the contractual ground?
Well, my lord, that may or may not have a bearing on the court's decision to make a possession order. But, my lord, the crisp answer...
Where do you find in Schedule 2, or anywhere else, that the court must, in addition to deciding whether the ground has been satisfied, also decide whether any contractual requirement for bringing the tenancy to an end has been exercised? You don't? No,
you don't. Your lordship's quite right, because 10 is one of a small group of grounds where it doesn't have to be reasonable to make the possession order.
Yes, so it's mechanical in its operation, subject to there being alternative accommodation.
Lord, the best way I can deal with it, respectfully, is that the break notice does not have any legal effect other than to bring the tenancy within the definition of 82(1)(b, subject to termination by the landlord.
And that doesn't always benefit the landlord, because the grounds may prove more restrictive. For instance, if there is misrepresentation in obtaining the tenancy, and you wanted to exercise a pure contractual right arising by operation of law, you could not do so.
No. UKAC. Islington and UKAC, I think, says that, yes.
But surely it wasn't any part of the policy of the Act to make the tenant worse off than he was under his contract by extending the grounds on which possession could be obtained. Must you not, to make sense of this, have to both demonstrate a contractual right and a statutory ground?
Well, Lord, a tenant could challenge, in response to a claim against a fixed-term tenant for possession, a tenant would be entitled to challenge the proposition that the tenancy is subject to termination by the landlord.
Yeah, well, you couldn't. You say all you have to do is say I've got subject to termination for some other reason. But I'm not actually relying on that reason. It's just there in the contract. So I'm in the door, and now I can satisfy any of these grounds.
Lord,
that's totally unreasonable from the tenant's point of view. They've got a contract which says I've got a fixed term except on one circumstance, and you say, oh well, because of that, I can actually terminate for all these other reasons. Bad luck.
I'm so sorry. It may be, my lord, that the tenant in those circumstances could set up a defence and say it's not subject to termination by the landlord.
How would a tenant in practice do that when we're dealing with tenants of this kind?
Well, in the possession proceedings, the tenant could say you're not entitled to rely on the statutory grounds for possession because you have this contract is not, on a proper interpretation, subject to termination by the landlord because you haven't complied with contractual obligations.
The key words here are not. 82(1)(b) could have said a tenancy granted for a term certain which has been contractually terminated by the landlord, and then you're in.
It could have said that.
It didn't say that, and I think your submission is that so long as the tenancy, the fixed-term tenancy, has some or other provision in it for termination by the landlord. Let's say if England became a republic, then you could exercise your rights to get possession under 1A, which is it's an order for possession, 1A1, on any of the grounds, any of the statutory grounds, nothing to do with England having become a republic,
Yes.
even when England had not become a republic, because it was subject to termination by the landlord. It had a termination mechanism in it that made it possible that the tenancy might end short of its full term.
Yes.
But that seems a remarkably tough way of construing the Act against tenants when its obvious purpose was to grant tenants additional security rather than less security.
No, but Lord, to provide tenants with protection in terms of the statutory grounds, that was the policy.
But the starting point was freedom of contract, wasn't it? And then it was seeking to say, well, you can't have absolute freedom of contract. You've got to come within one of the statutory grounds. But I don't see why you tie yourself to the position, unreasonable submission that if you get your foot in the door for one contractual ground, then the contract goes out the window.
No, my Lord, I except that in certain circumstances the tenant would be able to challenge the decision to bring proceedings on the statutory grounds on the basis that the tenancy was not subject to termination by the landlord.
Well, your interpretation is that that's the only requirement, and provided there's any form of termination clause, then all the statutory grounds are available.
Yes, well, Lord,
I don't see why you need to argue that. Why can't you say that the statutory grounds are an overlay which you have to satisfy as well as the contractual right of termination?
Well, there's certainly that, because of the history, we looked at it, my Lord, these arrangements were regulated by contract, and then the statutory scheme superimposed statutory grounds upon which to do that.
So that is the logical interpretation, isn't it?
I mean, with respect, it doesn't. I understand entirely why my Lord raises the question. It's not our case that we're looking at here, but it's right that the court should test to test the argument in that way.
What do you mean it's not our case that we're looking at here?
Well, in our case, we're looking at here, we're not looking at a redevelopment break clause, we're looking at a term which says...
No, because your clause sensibly corresponds to the statute, and it gives you a contractual right to terminate where there's a statutory provision that applies and not otherwise.
Yeah.
But the point was to make sure that there was always determination by order of the court, and not by the landlord unilaterally sending the bailiffs in.
Yes.
And that was essential for the rule of law in this, and access to justice in this case.
That was already in the Protection from Eviction Act.
No.
Well, you couldn't get possession of a dwelling house being lived in by a tenant without getting an order of the court.
Oh, it's about an order of the court, but I think, yes, but an order of the court based on statutory grounds.
Yes.
The bottom line is there can be no eviction, there can be no other way of doing it. There must be an order of the court based on the statutory grounds.
So if the Parliament was interfering with landlords' rights, it had in some way to draw a balance between the landlord and the tenant.
Yes.
And the way it's done it, on your case, is by saying it is enough if there's a contractual term for termination by the landlord, then it must all funnel through subsection 2. And then that's the balance being struck.
Yes.
But then why is there provision in relation to forfeiture that operates in a quite different way? A forfeiture is an obvious provision for contractual termination.
Yes.
But then it doesn't say, well, you have to show that you've forfeited, and then you can apply under any of the ordinary terms. What it there does is to treat the effect of forfeiture as giving rise to a statutory tenancy.
Yes.
Why doesn't it do the same in relation, for example, to a break clause? If it was contemplated that the existence of a break clause would be of any materiality to your ability to get possession.
Lord, I simply don't know the answer to that, because I can't read in what the Act said. We can only seek to interpret what's there.
And 186 is stark, isn't it?
Yes.
Because the actual mechanism which the Act uses to bring a fixed-term tenant into the same position as any other periodic tenant, namely by giving it a statutory periodic tenancy, only applies on a termination by fluxion of time or forfeiture. They haven't said or for any other, on any other contractual ground.
No, and we say that's because the tenant then, the landlord can then proceed on the statutory grounds and the tenant has protection in that way. 86 is really just, we say 86 just deals with two problems. What happens when the tenancy comes to an end contractually, and what happens when the landlord exercises forfeiture rights?
Well, no, because it's not when it comes, I mean, it might come to an end contractually by the exercise of a break notice, but it doesn't say when it comes to an end contractually. It says when it comes to an end by a fluxion of time. I don't think anybody would read the expiry of a break notice as being a fluxion of time.
No,
although in a sense it is.
No, that was my mistake. It comes to an end by a fluxion of time, the first one, or the exercise of a forfeiture clause.
But not the exercise of any other termination right.
No. No, but the reason for that is that provided you get into the statutory grounds, the protection for the tenant is that they give my 3 points at the outset. The tenant can't then be evicted. Whatever the contractual position, the tenant cannot be evicted unless the grounds are made out.
Section 86. You say the tenant gets that protection purely under 82.
Yes. 82 is the only section in the Act which actually protects the tenant from eviction.
But you want to construe it as not protecting the tenant from eviction in circumstances where it would have protection under the contract otherwise. Well, my Lord, it seems to me it's very damaging to your case to adopt that position. But it's your choice.
Well, my Lord, I would respectfully accept my Lord's analysis that the contractual position must remain as it is, but the grounds are seen as a statutory overlay.
And tell me then, if you look at 82(1)(b), you then put in the words, but subject to contractual termination, or the word. I was just trying to think of what term certain would not be subject to termination by a landlord. And so what term certain would not be subject to termination by a landlord?
Well, Lord, it may be, I mean, for example, if one looks at Woodford, it says denial of the tenant's denial of title is a ground that would entitle the landlord to end. So if that's right, then arguably that would apply to every fixed-term tenancy and removes...
Yeah, or fraud.
That's right. All I can submit is that Parliament must have envisaged back in 1980 that there would be two types of fixed-term tenancy, one which can be brought to an end during the term contractually, one means or another, and the other which couldn't. There's no need to give protection to the tenant in the latter case because the contract protected the tenant, but there was a need to give protection to the tenant in the first and former case, where it can be contractually ended by the tenant for whatever reason, and to ensure in those circumstances that the landlord is forced to apply for possession on statutory grounds. It's the best way we can analyse it.
And I'm sorry, why use the words, but subject to termination by the landlord? What's the purpose of that? Why not just say a tenancy for a term certain?
We can only submit that that's for the reason I've just given. It's trying to embrace all those circumstances where there is a right, an extended right in the landlord for one reason or another to bring the contract to an end.
Well, could you not read it as meaning subject to termination by the landlord in the circumstances which have arisen?
Lord, yes.
In other words, that there is a contractual right of termination, and then you can't actually bring it to an end, however, unless you get through the statutory requirements.
But then a tenancy would go in and out of the status of being a secure tenancy as time goes on. So you presumably expect Parliament to determine that question at once and for all at the start of the tenancy.
Well, it's still a secure tenancy.
Yes, but it would cease to be if the right had not become exercisable.
No, it wouldn't.
If you confine subject to termination by the landlord to a contractual right of termination, then you exclude protection from all those other tenants who would be subject to termination by, for instance, for fraud or for denying their landlord's title. Insofar as 82 states that it cannot be brought to an end except. And in one sense, the benefit of your analysis is that you make the protection under 82 as wide as you possibly can, because any method of termination. But then you pose the question as, well, what tenancy for a term certain isn't subject to termination by the landlord? And I still can't quite grasp what those are.
No. Well, Lord, I've answered. It may be that every tenancy comes within that provision. But I think the most important thing is to try and find a way of making the Act work in practical terms. And we submit that 82(1)(b) is the gateway. You have to demonstrate as a landlord that your tenancy is subject to termination. I fully take the Lord's point that it may be that the tenant can challenge that and say, well, actually it's not, because you haven't contractually ended it or whatever.
But if you read it as meaning subject to termination in the circumstances which have arisen, so you have to have a common law or contractual right of termination.
Yes.
If you don't have such a right, well, you can't terminate anyway.
Yes.
If you do, then you have to go on to satisfy the statutory grounds, and that makes sense of it, doesn't it?
Lord, respectfully, I would accept that. So, contract subject to termination by the landlord, having regard to the contractual rights between the parties, and then that's the gateway to the statutory grounds.
But isn't the potential difficulty that if a tenancy for a term certain is not subject to termination in the circumstances which have arisen, you can the tenant I suppose that, yes, I understand. That's okay. I apologise.
It's very odd that the statute talks about subject to, quotes, termination, quotes off, and then it says it can't be brought to an end, which one might have thought was, why didn't it just say terminated? Is there some difference in concept between something being subject to termination and something being brought to an end? I think what it might be.
Yes. All we can say is that the policy is to keep the contract, the tenancy in place until a court terminates it by making an order based on...
That's not how it works. That's not how it works in relation to forfeiture. The contract is not kept in place. The forfeiture operates in its usual way, and the statute then brings a new statutory tenancy into place in substitution for the former contract, which has gone. It's been brought to an end and it's terminated.
The fixed-term tenancy has come to an end. That's the effect of Section 8.
And you're into the periodic tenancy regime, to which all the grounds of possession naturally and easily apply and in relation to which they work.
Yeah.
But you say the way it works if it's a break clause is that the break clause is wholly ineffective actually to bring the contractual tenancy to an end. I think you have to say that because otherwise the Act would be defective in giving protection. So what you're then seeking to terminate by your order for your claim for possession is not a periodic tenancy, but it's still a fixed term tenancy.
Yes. It has to be.
One asks, why did the statute deal so differently between termination by way of forfeiture, which is effective but gives rise to a statutory tenancy, and termination by some other contractual method provided for in the lease that isn't forfeiture?
Well, we can only think it's because this was retrospective that Parliament must have thought there were two problems with fixed-term tenancies. What happens when they come to their natural expiry? And what happens when a landlord exercises a forfeiture right and brings it to an end? And that was the purpose of Section 86, to tie up those loose ends, or to ensure that in those two circumstances there will be security of tenure, and that the guarantee not to be evicted except on statutory grounds. We're not suggesting it's perfect. We're trying to construe what is difficult legislation for local authorities to apply and for tenants to be protected by. And we can find nothing that we think can assist the court on the meaning of those words, and therefore have to approach it in terms of first principle. I mean, our headline submission, conscious of time, the headline submission on what I've called the first limb, what is the meaning of the term subject to termination by the landlord, we make a number of points about the different language between that section and proviso forfeiture. We make those submissions. The Court of Appeal accepted those submissions. The Benyon point about where Parliament intends things to have the same meaning, uses the same words, all those submissions. But the overriding submission is, if you don't construe the word subject to termination by the landlord broadly to encompass all those contractual rights that the landlord has to terminate a contract, if you don't construe it that way and construe it narrowly, as the judge did, as just one of those, forfeiture, you leave a gaping hole for landlords. Now, I've got a case, whether I'll have time to come to it, Lord Hoffman again, on section 52, which was a contemporaneous provision, which says where Lord Hoffman characteristically sees the problem with the scheme and says a landlord could simply get round this by serving a break notice. The same would apply here. If you didn't construe the word subject to termination by the landlord broadly as embracing all contractual rights, as Lord Justice Arnold accepted it should be construed,
Yes.
then you do not give protection to the tenant, because the landlord can simply lawfully avoid the consequences of security of tenure. You know, that's, to save time, that's our headline point on our limb 1 of ground 1. Can I proceed then to limb 2?
Could you just, possibly, for my assistance, if not anyone else, just work through what you say happens under the provisions relating to this, to rights of forfeiture under Section 82, that's subsection 3 and 4. The effect, I think, is very limited, but I think we want to be clear what you say the effect is.
Well, what we say about them, my lady, is that Section 82, my lady, has the headline submission. Where the tenancy is subject to termination by the landlord, we've had a discussion about that, then the landlord is entitled to elect and may proceed for a claim for possession on a statutory ground. Alternatively, if the landlord, and there may be circumstances in which it's to the landlord's advantage to do this, there may be circumstances in which the landlord, with a forfeiture clause, wishes to forfeit. A landlord cannot forfeit under this legislation because that's not permitted. What is permitted is an application under Section 82, subsection 3 for a termination order, which we see from the language would only be allowed if the landlord had forfeiture-type grounds. Yeah. So there may be circumstances, and this is in response to Lord Justice Arnold's point about redundancy, there may be circumstances where the landlord's need to recover possession or desire to recover possession doesn't overlap with the statutory grounds, maybe bankruptcy or insult, something like that. There used to be, I think there was experimentation in relation to domestic violence clauses before the Act was amended to deal with this. So there may be other reasons why, tactical reasons, why a landlord would wish to go down the forfeiture route rather than the possession route. But it can't. It's shut off by Section 82.3.
That's the effect, isn't it? It brings it back into the funnel.
Brings it back into that. I made the submission, which wasn't accepted in the Court of Appeal, but I repeat it here, that there's an element of anti-avoidance about 82.3. It's to make sure the landlord can't get round the statutory scheme by forfeiting.
Right. Yep, that's I understood you to be.
It could terribly easily have just said, in fact, if the three hadn't been there, you would still read 82(1) as saying, even if it's subject to termination by forfeiture, the tenancy can't be brought to an end, and it remains a fixed term tenancy, and you just apply under your grounds for possession.
Yeah, yes, I accept
you
that.
wouldn't need three. Three introduces a whole new way in which forfeiture works. It's no longer a right of re-entry.
No.
You forfeit the lease, that is the 21-year species of property, and it's replaced by a statutory tenancy.
It's replaced by a statutory tenancy. The only sense we can make of it, respectfully, is it's shutting off that possibility that the landlord can get around the statutory grounds by the forfeiture route. So I would respectfully repeat the submission that there's an element of anti-avoidance about it. Now, can I proceed to limb 2 of ground 1? Does Section 82 require the landlord to exercise the forfeiture style route to termination before it can seek to recover possession? So this is really the main point of this appeal. Can the landlord, whose tenancy is subject to termination by the landlord, can the landlord proceed directly to a possession order, or must they in every case go through this termination procedure, for which they need both a forfeiture clause and forfeiture grounds? That's clear from Section 82(3). They need both. That's really the nub, we say, of the appeal. That's the really important point for local authority land and other landlords, and also tenants as well, those advising tenants. Really why we're here. We make a number of submissions about the ordinary and natural meaning. Perhaps if we could just make sure we have Section 85 in front of us.
'85.
So sorry, 82.
Yes.
3 through 6.
Yes.
So it's really, the question comes down to, is this section to be read as sort of horses for courses? That is to say, the only way that you can bring a periodic tenancy to an end is by grounds under 1 big A, little a, and that the only way you can bring a tenancy for a term certain to an end is by the termination order? Or can you bring the termination order to an end also by showing statutory grounds? That's essentially the question. And we make a number of points on that. The first, we say, by reference to the ordinary natural meaning, is we say if we look, please, at subsections 1 and 1A, I'm sorry, my lord, my note refers to the 1980 Act, and the reason for that is because the Court of Appeal was construing that. Could we please just turn that up for this purpose? I knew we'd have this, or I would have this difficulty jumping between 296. So if we look at section 32 as it was, this is the section the Court of Appeal construed, 296. A secure tenancy which is either a weekly or other periodic tenancy or a tenancy for a term certain but subject to termination by the landlord cannot be brought to an end by the landlord except by obtaining an order of the court for the possession of the dwelling house or an order under subsection 2 below. And where the landlord obtains an order for the possession of the dwelling house, the tenancy ends on the date on which the tenant is to be given up possession in pursuance of the order. The first submission we make, that on an ordinary natural reading of the subsection, tenancy is mentioned 4 times. The first is to describe both a weekly or periodic and a fixed term tenancy. The second time is to describe a periodic tenancy. Third time is to describe a fixed term tenancy. And then the fourth time is the only occasion on which it's preceded by the definite article, the tenancy ends. And on an ordinary natural reading, where a word is preceded by the definite article, it refers the reader back to an earlier use of the tenancy, the word, and the obvious reference point here is the first use of it. So to put that submission together, the tenancy on which the tenant is to give up possession ordinarily and naturally means the tenancy which is either a weekly, periodic, or a fixed term. So that's our first submission, that reading the ordinary words, in fact, I think it's recorded in the judgment that the respondent didn't dissent from the view that the reading that Croydon asserts is an available one on the wording of the statute.
I don't really see where this point goes, because that part of the clause only applies where there's an order for possession. Yeah. So it begs the question of in relation to which kind of tenancy can you get an order for possession?
Well, Lord, it does, but I'm simply
addressing... The better point is it simply doesn't say that the order for possession is limited to cases which are the periodic tenancy. Rather more straightforward point.
Lord, yes. Can I just... I want to take this... in the time I have. The way the Court of Appeal approached this was the Court of Appeal looked at Section 32 because they thought it was clearer, the position was clearer than looking at 82, our section. They looked at Section 32. They accepted that the construction that Croydon contends for was an available construction on the words. But they were, Lord Justice Arnold felt that it was necessary to read the word respectively in to the section, so to make it clear that weekly tenancies, periodic tenancies are brought to an end in one way and fixed term tenancies in another way, and drew support from that from various other sources. One of them was that if you don't construe it that way, subsection 2 becomes redundant. That's the termination, because the landlord would avoid that by just claiming possession. I think I've made my submission on that already, that there's no redundancy there. The landlord who wants to forfeit has to go through that route. And there's certainly no avoidance, because a landlord cannot exercise forfeiture rights other than by doing that. If the landlord wants to forfeit, it has to do it in that way. And then the Court of Appeal drew upon, I think there were 3 sources supporting the Court of Appeal's analysis of this. The views expressed by practitioners at the time, necessarily if we have the time we'll look at those, but we respectfully said that their opinions to be respected. They're not reliable guides or necessarily guides to the way that the legislation should be construed, certainly not by this court. And thirdly, although this wasn't, as I read the judgment, a major reason, more of a comforter, that this appears to have been the way the Secretary of State had construed it when drafting the notice procedures. So that in a nutshell is that. To save time, because the court has our printed case, I want to go to where we say, respectfully, the Court of Appeal was wrong on this, and why I'm looking at Section 32 now, but Section 82 is our current section, why that should be construed in such a way that the landlord with the right to terminate, as we've discussed, can then apply for a possession order can go directly to 82(1) capital A little a. And we say so for 3 reasons. Each reason applies. It's set out in our case, paras 46 to 52, 3 recognised canons of construction. The first is the presumption against Parliament overriding common law rights except by clear language. We've given reference to Lord Hutton in the Rotman case. Quote, "It is well-established principle that a rule of the common law is not extinguished by a statute unless the statute makes this clear by express provision or by clear implication." And more recently, Lord Dyson in the CPAG, Secretary of State Work and Pension case, where set out similar principle. And we say there is an override here. If you construe the words subject to termination by the landlord, as we invite this court to construe them, as the Court of Appeal construed them, as embracing all contractual rights, then to provide that the landlord can only proceed by the forfeiture style route is necessarily overriding the rights, those rights. And that can only be done by clear language. Parliament can override common law rights, it can override contractual rights, but it does so by clear language. And our headline submission is not only is that clear language lacking, but the Court of Appeal found it necessary to write in a word, an important word, respectively, that's a policy word, in order to achieve the result. And we do in our case, I don't think time permits me to go through there now, but we do in our case invite the court to contrast Section 32 of the 80 Act with Section 52 of the same Act, which introduced protected short-hold tenancies, which is the private sector equivalent of what is now the assured short-hold tenancy. And there we have language which is far clearer, more clearly Parliament overriding. I'll just turn it up so I can just read it to the court. Section 52. This is page 307. A protected short-hold tenancy is a protected tenancy granted after the commencement of this section, which is granted for a term certain, so on, which cannot be brought to an end by the landlord before the expiry of the term, except in pursuance of a provision for re-entry or forfeiture. So in the same Act, Parliament is there acknowledging, we say, other contractual rights vested in the landlord to override, and by clear wording excluding them. We do not see that in what was Section 32, now Section 82. So our first canon of construction, which we say is supportive of our case, is the presumption against Parliament overriding except by clear language. Our second canon of construction, and this we respectfully submit is a particularly worrying aspect of the Court of Appeal's judgment, I can put simply like this. If it's right, if the Court of Appeal is right, that the only way in which a landlord under a fixed-term secure tenancy can bring that tenancy to an end during the term is via the forfeiture termination route, if that's right, and the forfeiture termination route requires the court to be satisfied that the landlord has forfeiture grounds, then unless the landlord has forfeiture grounds, it cannot access the statutory grounds. We just go back, please, to those statutory grounds, and we're now going to have to grapple with the numbering, I'm afraid, but we'll do our best.
Yes.
So they start at page 437. 437. And I'll take this as swiftly as I can, but I do need to make the point. At 437, we have, this is Schedule 2 to the Housing Act 1985, and these are the statutory grounds. So I'm afraid it's very difficult to follow, and if you look at the italics at the bottom below the notes, you will see Schedule 2 and then the ground and the number, ground 1. So page 437 is ground 1, which is rent arrears or other breach of obligation. That's clearly fault-based. In fact, they're all fault-based up to a point. So ground 2, 438, that's antisocial behaviour. Ground...
Where do we see that? Sorry, just so I can understand 438. It's the main text, is it?
Yeah.
Yeah.
I see, right.
Yes,
okay.
the tenant person residing has been guilty of conduct likely or cause unlikely to cause a nuisance.
Yeah.
And then 440 is a new ground, 2ZA, and this is tenant convicted of an indictable offence. Again, that's fault-based. And then 441, we have a new domestic violence clause, provision or ground, 2A. Again, that's fault-based. 442, this is tenants neglect waste, that's fault-based. 443, ill treatment of furniture. 444, tenancy fraud. 445, ground 6, is unlawful premium on assignment. 446, ground 7, tied accommodation tenant misconduct, all fault-based. And then 448, ground 8, temporary works, essentially where the tenant has been allowed into occupation pending works to another property, and they've agreed to leave, and they haven't, so arguably fault-based. And then 449, we then get the first of 3 sections to which reasonableness doesn't apply. All those up to that point, court must be satisfied it's reasonable to make an order.
That's correct.
449, this is statutory overcrowding. Now, query whether that's fault-based, may or may not be. But 450, ground 10, is redevelopment.
Yeah.
Massively important ground for local authorities. It's available against a tenant who is impeccable. And the court cannot even consider whether it's reasonable. Now, we ask rhetorically...
The court can't also stay any order as well under section 85.
Yes.
Ground 10, the court's got no other power.
The court has no... I'm grateful, my lord, for that. The court has no power at all for that. Absolutely. This goes back...
But if a local authority has granted a 21-year lease to a tenant or 100 tenants, why should the Act be construed as taking that 21 years away from them, merely because in year 2 the landlord decides he wants to redevelop? Because
it's public sector housing. Because it goes back to that passage in the...
But if you ask yourself that, assume there were some 21-year leases around the day before the Act was passed, didn't contain a redevelopment break clause.
Yes, my lord, sorry, I should have made it clear. We're not in reasonableness territory here.
No, I appreciate
there is an obligation to provide alternative accommodation.
I understand all of that. But if the tenant had a species of property which a common law entitled him to stay in the property for 21 years, providing he didn't misbehave, i.e. it had a forfeiture clause, but it didn't have a redevelopment break clause. It's a strange construction of the Act, which is designed to increase tenants' security, that the day the Act comes into force, they're liable to be evicted on redevelopment grounds.
No, my lord, respectfully, no. It's the twin objectives. It's the twin objectives, on the one hand, to protect the tenant, and on the one hand, to make sure, this is much clearer when we get to some of the later grounds, to enable the local authority or the landlord to exercise effective management. Now, if To take the Lord's point, it could be a 21-year fixed-term tenancy. That would be a secure tenant, or that could be a secure tenancy. If a couple of years in, the block in which the flat is situated is badly damaged by fire, the flat is still habitable, the tenant not unreasonably on one level refusing to leave, but the local authority need to demolish the block quickly in public interest to do so, that ground comes into play. And the submission is, on this second limb of the ground one of appeal, the submission is that if the Court of Appeal's approach is right, and the landlord can only access these grounds via forfeiture, where is the ground for forfeiture when you're redeveloping? Can we just look?
Just taking that point on a bit further, the local authority, a private developer needs to buy out a lease or somebody else's rights.
Yes.
And can be held to ransom by a person who owns those rights. But a local authority may be in a somewhat different position insofar as they have control of public money. And so why should the tenant, therefore, gain by saying, well, you just buy me out if you want to get rid of me? And so...
Well, yes. Again, respectfully, that supports the submission that the other side of this, there are two twin objectives that come from that green paper. One, to give security of tenure, but secondly, to recognise, I can't remember the exact words of the green paper now, the special position of local authorities in managing their stock. Can I just get to, please, can I get to grounds 11 to 13? Because I think these do really, 12 to 14, forgive me. 11 is
charity objects.
Is charitable objects.
Could you just give us the page for that, please?
Sorry, page for it is, we start at 12, 453.
Yeah.
Is tired accommodation. Again, simply that there's no longer a requirement for the tenant to be in occupation. There's no suggestion there that a tenant's fault. And then come to 13 at page 455, ground 13. If I could just read this, because it's the first of a trilogy of grounds which are all aimed at a similar mischief. The dwelling house's features, which are substantially different from those of ordinary dwelling houses and which are designed to make it suitable for occupation by a physically disabled person who requires accommodation of a kind provided in the dwelling house, and there is no longer such a person residing in the dwelling house, and the landlord requires it for occupation, whether alone or with other members of the family, by such a person. Now, to answer my Lord Biggs' point, or to put that in context there, yes, a local authority could grant a tenant 21-year secure tenancy, and in the second year, that's of a property that's been specially adapted. In the second year, the person for whom the adaptations were made goes into residential care. Yes, the local authority can recover possession, and the mischief of that is clear, because there's no longer a need in that household for the adaptations, but the local authority will doubtless have a list of other applicants needing such accommodation.
It seems rather fanciful to think that a local authority would grant a fixed-term tenancy of property of that kind, where it was foreseeable at the time of consideration of the grant that the person might no longer need that particular accommodation. They might get better, for example. And it's entirely understandable why that ground will be there in relation to a periodic tenancy. Lord, indeed, one can say that of all these no-fault grounds. If it was common law, you can terminate a periodic tenancy without giving any grounds. Under the statutory scheme, you've got to have a statutorily recognised good reason for doing so.
Lord, the scheme is drafted, it envisages, the way the scheme is drafted, it envisages that local authorities will grant or may grant fixed-term tenancies. And the Localist Act, of course, encourages them to do so. They may not know at the outset, the local authority may not know at the outset that the property is going to be badly damaged by fire, or that asbestos will be found, or that the a member of the household acquires injuries which require special adaptations, and then a year or two later dies or goes into residential care, something like that. So, with great respect, cannot look at it in what the local authority can foresee at the outset. The whole point of these grounds is to give flexibility to the local authority, but by headline submission is on this, and we also grounds 14 and 15 to very similar effects. The headline submission is that the local authority couldn't possibly get a claim off the ground via the forfeiture route. Where's the fault? Where is the default when you're claiming possession purely and simply on the basis that there's no longer a need for that type of accommodation? It's clearer still when we go to page 458, which is ground 15A. I accept that this is a later ground, but we're looking to see how this Act can work coherently. 15A 458. And in a nutshell, this is under occupation. There was a previous version of this, but typically the tenant dies, and very often this is an elderly parent and a grown-up son or daughter or whatever. The tenant dies and the property is larger than the successor would ordinarily require. Now, the value of this ground actually refers specifically to fixed-term tenancies, and that, if one looks at little a, the dwelling house in England, the accommodation afforded is more extensive, and the tenancy vested in the tenant by virtue of Section 89 or Section 90, devolution of terms certain, in a case where the tenant was not previously tenant, spouse or partner. So here we've got a ground which is actually directed, contrary to the Court of Appeals analysis, at a possession order of a fixed term, a tenancy. And we only have to look at this scheme, this mini scheme in 15A. There's a window of opportunity to serve notice on the tenant. You can't do it less than 3 months, the sort of grieving period, and you can't do it more than 12, by which time, no doubt, the successor tenant will have a sense of security in the property. So again, how applying the Court of Appeals analysis, this section, which, if I'm permitted to say, is one that local authorities often rely upon, this section is inaccessible. How can the Act be construed in such a way that the ground is unavailable to the local authority? It simply doesn't work.
If you accept my suggestion, which you did rather reluctantly, I think, that you have to have a contractual right.
Yes.
The question then becomes, if you do have a contractual right to terminate, let's say for redevelopment, what is the policy which says that you shouldn't be allowed to exercise it in the case of a fixed term unless you can forfeit first for some other reason? To which I'm not sure at the moment what the answer will be.
Well, Lord, I accept the Lord's last proposition about that, and I think I don't know whether I can take that any further.
No, I mean, that's a question in your favour, as it were.
Yes.
There may be a similar point in your favour under ground 5, because this is where the tenancy is granted as a result of a false statement.
Yes.
If one's thinking of these as only working in relation to periodic tenancies where there has been a forfeiture if it was ever a fixed term, one would ask, well, why, as a matter of policy, if you can terminate a periodic tenancy on this ground, shouldn't you be able to terminate a fixed term tenancy on this ground, even though it might not in terms fall within the confines of a forfeiture clause? Because if the misrepresentation was made before the grant of the lease, it probably wouldn't.
Yes.
It's a point in your favour. I'm just...
No, I understand that, yes. Has your Lordship looked at the UKAC and Islington Point case?
Not yet.
It's in the bundle.
I mean, I've seen what's said about it in the bundle.
Yes. But that was a case on ground 5 where the Court of Appeal held that rescission or misrepresentation or for fraud wasn't available
Yes.
under this legislation. It's the case which says that everything goes through Section 82, the statutory grounds.
Oh, and it didn't fall within ground 5, is that right?
No. What happened? It was the problem with UKSC, Lord, was that the misrepresentation was by an assignee,
Oh, yes.
and that didn't fall within the words. If one is construing ground 5, page 444, if one is construing that technically, then we run into difficulty again with the Court of Appeal's analysis, because it reads this is a very important ground, this is tenancy fraud. The tenant is the person or one of the persons to whom the tenancy was granted, and the landlord was induced to grant the tenancy by a false statement made or knowingly or recklessly by the tenant or person acting under the tenant's instigation. If one is forced to go through the termination route, the tenancy of which the court is being asked to make a possession order isn't the fixed term tenancy, it's the statutory Section 86 tenancy. And the Court of Appeal in UKSC said, not surprisingly, this is fraud, it has to be construed strictly. Reading that strictly, it wouldn't apply. If you have to go through the termination route, then the tenancy of which you're claiming possession wasn't induced by fraud. It was a statutory tenancy created by Section 86. Yeah. So there are structural problems. Well, my Lord, I go back to Lord Justice Mummery, who said you've got to read this strictly because it's fraud.
Yes, but induced to grant
yes.
is plainly talking about the original tenancy. I mean, however strictly construed, not the statutory tenancy.
No, Lord, I can understand that there might be a purposive way of looking at it. It's not the best point, but it's there. It's in our case. But I think Lord has the burden of our argument on the second canon of interpretation. I have put in the case a quote from a dictum from Lord Millett about unreasonable. It's in Edison and Central Valuation Office, tab 30. Lord Millett said that legislation must not be construed in a way which is objectionable or undesirable or absurd or unworkable or impracticable or merely inconvenient or anomalous or illogical or futile or pointless. There's a fairly full menu there. And we bring this canon of construction under that heading. And then our third canon of construction that we rely upon is statutory purpose. And we've put in the Court of Appeal's judgment in the Pollen Estate Trustee and Revenue and Customs Commission, because that's the case, tab 28, para 24. If I could just go to that, please. So that's forgive me, tab 28, page 719.
And what's the heading? What's this heading of construction?
Statutory purpose.
Sorry?
Purpose, statutory purpose.
Right, yeah.
So my first one was overriding common law rights. My second one was unreasonable result, undesirable results. That's you can't access we say the majority of the statutory grounds are simply beyond the reach of the landlord. If the Court of Appeal in a fixed term tenancy situation, if the local authority is right. And the third one is purpose. Now, Lord Justice Lewison, I think, would have had me put these round the other way because of what he said in part about the it's a para 24.
Page.
Sorry, forgive me.
Page. Oh, I'm there. I think it's
Yeah.
It's page 726.
Yes, I've got the wrong. Which page is it?
726.
726. Thank you.
Where it starts.
Yes, I'm very grateful to my Lord for that. 72624. The modern approach to statutory construction is to have regard to the purpose of a particular provision and interpret its language so far as possible in a way which best gives effect to that purpose. Then over the page B, this is page 727. The essence of this approach is to give the statutory provision a purpose of construction in order to determine the nature of the transaction to which it was intended to apply, and then to decide whether the actual transaction, which might involve considering the overall effect of numbers, answered to the statutory description. So the modern approach is the purposive approach, and I go back to our green paper and our twin objectives, which even if the court's not prepared to look at a green paper, this court has in the past, of course, looked at a green paper to understand the background to legislation. But in our respectful submission, it's perfectly clear, looking at the layout of the Act in any event, that the twin purposes for these purposes are to give that statutory, that legal recognition of the tenant's security of tenure, the guarantee to the tenant that they cannot be evicted except on statutory grounds, and at the same time the recognition of the special, quote, special position and responsibilities of housing authorities when crafting the statutory grounds. And all those grounds, one can look a whole range. When one goes through Schedule 2, you see a range of policy initiatives: antisocial behaviour, domestic violence, redevelopment, specially adapted accommodation. And that recognises the truth behind this legislation and why we're dealing with a different scheme to that which governs the private sector, because we're talking about social housing. Social housing comes in from many different streams, or applicants come in. Maybe homelessness route, adult social services, children's services, prison leavers, Mental Health Act cases, the whole lot. Very, very special. The local authorities and other landlords are dealing typically with very needy and highly vulnerable tenants, and they must have the ability to manage their stocks responsibly. And the big worry, the concern about the Court of Appeal's approach to this, which we say respectfully but firmly is wrong on the words of the statute. As a matter of syntax, it's simply wrong. But when one stands back and looks at purpose and looks at the other problems we've got, how can it possibly be right? What possible policy driver is there that forces the local authority into a situation where it's locked in, except on forfeiture-style grounds, which cannot assist it in a number, we say the majority, of the statutory grounds? Lord, that gives me 10 minutes to deal with ground 2, subject to questions. Can I
have a slight worry about how all this works in relation to flexible tenancies. Because as I understand the quid pro quo under the flexible tenancy regime, it's meant to be, because the tenant gets pretty well an assurance of a certain fixed term, I forget how long the minimum is, it 2 years?
2 years minimum, typically 5.
Then the landlord has a much easier task in getting possession at the end of that fixed term than if it was an ordinary secure periodic tenancy.
Yeah.
But I think you say, actually, there is no quid pro quo because the landlord has all those powers from day one under a flexible tenancy.
Yeah, subject to the regulation of the Act. Tenant can't, landlord can't just throw them out.
No. But the fixed term is illusory because I think you say, notwithstanding that it's got a 2-year fixed term, in fact, the landlord can rely on any of grounds 1 to whatever it is, 15A or more, on day 2 of the 2-year term.
Yes, of course.
So why is the tenant what's the quid pro quo for the tenant for being subject to much less security of tenure at the end of the 2 years if all these provisions are available to the landlord during the 2 years?
Well, the tenant is at risk, I accept that, but the tenant does get the assurance of a fixed term.
But he doesn't, does he? Because he's subject to being got out on any of these grounds.
No, I accept that, but if the tenant, the tenant gets the assurance of a fixed term, if the tenant complies with the terms of the tenancy, sorry, I didn't.
No, I'm listening.
If the tenant complies with the terms of the tenancy, they're not going to be evicted on the fault-based grounds. But it is, social housing is, in that sense, always subject to the strategic needs and rights of the landlord. It's clear from the scheme. That's what Parliament intends.
I just want to be quite clear. You are saying that the landlord has all the non-fault-based grounds of possession, even during the first 2 years of a flexible tenancy.
Oh yes, I do say that. I say that very clearly.
So the tenant is no better or worse off than if it was a perfectly ordinary periodic tenancy.
Well, a well-advised tenant might raise that point in relation to the Section 107A notice of offer. But, my Lord, the answer, the crisp and straightforward answer to your Lordship's question is yes. From day one, that tenancy is potentially liable to determination on the statute, and respectfully, rightly so.
Okay.
If the specially adapted property is no longer required a week after the grant of the tenancy.
I can see all sorts of good policy reasons why there may be, in individual cases, a good reason to get a tenant out. Anyway, thank you. I'm sorry you've got...
Then he'd
No,
have
not
right
at all.
to alternative accommodation.
Yeah.
Yes, I'm very helpful. The restriction on variation of fixed-term tenancy term is another advantage that the fixed-term tenant has. I took the law to Section 102. There are, I think Mr Arden, in his 1980 commentary, we've mentioned it, Mr Andrew Arden, Queen's Counsel now, well-known commentator on this, in his 1980 commentary. That one wasn't eBay. Makes the point that, and we put this in our case, that one, I'm paraphrasing, but one possible reason for the landlord going down the quasi-forfeiture route is to fire a warning shot across the tenant's bows, as it were, and to bring it down from a fixed term to... So there are rights that vested in the fixed term tenancy not enjoyed by the periodic tenancy. But on ground two, really, what I want to do on ground two in 5 minutes...
I'm sorry.
is I just want to go to the headline, because, and I would respectfully refer to our printed case on this, but the question, it only arises in very, very limited circumstances if this court prefers the approach of the judge, because I've made it clear already we were not forfeiting this tenancy. But if we need a forfeiture clause, then on a proper construction we had one. And the clause that I really rest on is that clause which says if at any time during the term of this tenancy the grounds for possession arise, we can bring proceedings against you. And we say that that is a Clay's Housing and Patrick clause. Now, Clay's Housing and Patrick is generally regarded, certainly by Woodfall, as the leading case on the definition of
Forfeiture clause.
Of a forfeiture clause. Just trying to find, where is Clay's? 20. 620.
Yeah.
It was held in Clay's not to be a forfeiture clause, and if we had time, I would have taken the court to Richard Clark and Widnall, which the Court of Appeal in Clay's thought was a good example of a case which was a clause. But if we go to 625, this is the judgment of Lord Justice Fox in the Court of Appeal, And at the top of 625, we have what is now the acknowledged test, certainly in the textbooks, as to the test for a forfeiture clause. We accept for present purposes the submission on behalf of the cooperative that a right to determine a lease by a landlord is a right of forfeiture if A, when exercised, it operates to bring the lease to an end earlier than it would naturally terminate, and B, it is exercisable in the event of some default by the tenant. The reference to natural termination of this definition means, in the case of a lease for a fixed term, the contractual expiry date. So we say that the term in the Respondent's Tenancy Agreement, which said that we can apply at any time for a possession order on grounds, if grounds arise, that ticks both Clay's boxes. Its effect is to bring the tenancy to an end prematurely, and it arises at least, in some cases, on the default of the tenant. Now, the point that was taken against us, or held against us, both before the judge and ultimately the Court of Appeal, is that it doesn't do that. It's not a tenancy, it's not a forfeiture clause. A forfeiture clause must be a guillotine clause. You must come down and end the tenancy. If you then go off to court to exercise rather than exercise physical re-entry, that's another thing. But the point ultimately held against us was it doesn't bring the tenancy to an end. And the submission there is very simple. Any such clause would be unenforceable, if not unlawful, because of the scheme of secure tenancy. It had no legal effect at all.
It can't be a right of re-entry? No, because the statute says it doesn't give you a right of re-entry.
No, the only thing in this scheme that can bring the tenancy to an end is a court order. That's the only thing that can bring it to an end. So it's a pertinent question, how would one fashion a forfeiture clause for a secure tenancy unless one enters into legal fiction? And I go back, I don't apologise for making this submission, we're dealing with highly vulnerable, needy people. Even back in 1977, part of the government was saying, make sure the tenancy conditions are simple and straightforward. I don't mean that in any derogatory sense, and the Lord understands that part of the submission. Why write it? Why is it the local authority or the landlord has to write in a legal fiction to say it will do something, we will terminate your tenancy forthwith, when it has no reason? To an extent, the Law Commission grappled with this problem in the second of its rather scathing reports. We have one in the bundle on the law relating to forfeiture. So we say respectfully, a proper forfeiture clause in relation to a secure tenancy is one that says, where you have a fixed term, if grounds arise, because that's the only way they can get a possession order in order to bring their tenancy to an end if grounds arise, if grounds arise, we will do the only thing that we're permitted to do by law to bring this tenancy to an end earlier than it would normally contractually come to an end.
Namely, go to court.
Namely, give a notice seeking possession, and go to court. That's the only way it can do it. Anything else beyond that is a legal fiction.
Well, you'd also have to comply with 146 as amended, I think.
Yes.
That's 82 sub 3, isn't it?
Yes.
Yeah.
Yes, because of 82 sub 3.
Yeah.
Sub 4.
Oh, maybe 4.
Oh, sub 4, yeah. So, in a nutshell, we say respectfully, if we have to show that we have a forfeiture clause, and as I say, this point may well be of interest to a number of local authorities. Now, the respondents in their case respectfully caution this court against saying anything in relation to forfeiture which might have an impact on other areas of landlord and tenant law. We said he'd only invite the court to do that because what we're saying is that we're in a very, very special, unique situation here where you have a statutory overlay, a statutory scheme which prohibits which invalidates any notice by the landlord to end the tenancy by a notice.
I think we've...
No, may I have a moment?
Yes.
Thank you.
Well, thank you, Mr. Rutledge. I'm sorry we interrupted you so much, but I have to say that, as usual, the interchange was of great assistance.
Lord, not at all, man. I don't agree with that. And Lord, we have set our case out as best we can in the printed case, and any further questions we'll be happy to answer them later.
Very good. 2 o'clock.